Welcome back once again to Civil Discourse Now. I'm Mark Small. My co-host is Paul Ogden here. We're both attorneys here in Indianapolis, Indiana. We're discussing today whether public intoxication should be a criminal offense. And I just want to point out, this is St. Patrick's Day, March 17th, 2012. I could tell some Irish jokes, but that would be in bad taste.
You'd have to bleep, probably.
It would be an ethnic slur. And I wouldn't say, for example, what the difference is between an Irish wake and an Irish wedding is one less drunk. But, Paul, you were going to make a point right before we broke.
Well, you were making a point about your wedding invitations and how you encourage people to seek alternative transportation around usually New Year's Day or Halloween, probably St. Patrick's Day.
And July 4th.
And they're all the time running ads about, they put a billboard saying, use a designated driver. State police say that. In fact, I think the Marion County prosecutor and the Marion County, or the Indianapolis Metropolitan Police Department also had put out notices about using that. The trouble is, you can still be arrested for public intoxication. You can be arrested under the Moore case, being a passenger in a taxi, having a designated driver, or even being on the bus, I would think. Those are public places.
Literally, the Moore decision makes all of those appeals to the public to seek alternate transportation and to use designated drivers, literally encouraging you to go out and commit a different crime.
Right.
Don't commit this crime, commit that crime.
Well, let's go through let's do anatomy of a public intoxication arrest. First of all, John, let's say I walk out of a bar, let's say this afternoon.
Which will probably happen.
At 3:30 or 4 o'clock, and an officer says, stop, I want to talk to you. What should a person who would be prudent in wanting to minimize risks of prosecution and conviction, what would be prudent for them to do?
Not stop. Continue to walk.
Because there's no law that requires you just to stop because a law enforcement officer has told you to.
That's correct.
If he says, I'm telling you to stop, I'm ordering you to stop.
Then the first response should be, how long do I have to stay here and why can't I leave?
And then at some point, you say, may I leave?
You should early and often repeat the question of when you are free to go in that exact term. When am I free to go? Am I free to go now?
If an officer asks an individual, have you been drinking, does that person have to answer that question?
Fortunately, we're in the United States, and anytime the police ask you a question, I tell my clients this repeatedly. You have two options. Tell the truth, or say, I'm not going to answer any questions.
So, let's say the officer says, and we're not talking about operating while intoxicated. That's a completely different character of offense.
If you get into a car and you operate on the roads, whether they're public or private, you have surrendered some of your freedom from reasonable inquiry by the police. So if you are operating the car and you commit a traffic infraction, intoxicated or not, the police automatically have the right to stop and detain you, to address that infraction, and to start asking you questions about your driving and what they've observed. So it's a given that that is a completely different situation.
But let's say, okay, so we're in public intoxication, that area. The officer asks the individual to perform field sobriety tests. What are those?
The standard field sobriety tests, and there are 3 that the National Highway Traffic Safety Administration claims have some validity. That's the walk and turn, commonly referred to as 9-step walk and turn, heel-to-toe walk, you may hear, the one-leg stand, where you stand on one leg, count to 30, and the horizontal gaze nystagmus test, which is follow my pen. Exactly.
Okay. Now, I have multiple sclerosis. When I went in for my appointment with the neurologist, who will remain unnamed, he was not a very good neurologist, but when I went into his office, he administered the 9-step heel-to-toe walk, the horizontal gaze nystagmus, and the one-legged stand, and I flunked all three, and those were means by which they kind of initially thought I might have MS. So those aren't necessarily valid indicators of intoxication, are they?
No, they're not. The horizontal gaze nystagmus is the only one that has any scientific basis. It is a medical test. It's a diagnostic tool that physicians use to determine if there is a central nervous system impairment. Not if there is a specific alcohol-related or drug-related or physical illness or disease-related, but generally, is there something that is causing the central nervous system of this person to not operate normally?
Joe, from your experiences as a bartender and as a bouncer and as a DJ, do people sometimes, when they're really hammered, present as being completely lucid and sober?
Yeah, absolutely. They have different tolerances and abilities to handle their alcohol, and there were times where I'd be absolutely hammered in the DJ booth, and you couldn't tell. My performance was no different, but I was pretty good and snookered.
And there are people who present as being intoxicated when in fact they haven't had anything to drink at all.
There were numerous occasions where, working as a bartender, I would either serve someone that was acting weird as soon as they came in. I not knowing whether they were drunk or not, I would underserve the alcohol served to them, but they would pretend like they were just far drunker than I knew they could be.
Yeah, or some people might not have had anything to drink at all.
Right.
It's because they have some type of a slur, they have unsteady gait.
I've seen diabetics that look like they're just completely drunk and haven't touched a drop in their life.
But when it comes to the breathalyzer and the BAC, which is separate, right? You have breathalyzer and the blood alcohol content test. Your ability to appear sober and that alcohol doesn't really affect you in terms of these field tests, that wouldn't affect the breathalyzer. I don't know if I said that right or not.
Well, if you're ever in the unfortunate situation of facing an operating while intoxicated charge, Indiana and most states have structured that offense into two separate crimes. The first one is operating while intoxicated. The second one in Indiana is operating with an ACE, alcohol concentration equivalent, of some level or more. So there are two separate offenses, 08 to 14 and 15 or above. In the traffic code, the definition of intoxication is impaired condition of thought and action and loss of normal control of a person's faculties. There is nothing in that definition that refers to a number. So if the machine breaks, if they can't get you to a machine because you're injured, or if you refuse to take the test, they can go forward on the intoxication count with no number. The operating with an ACE over the legal limit is operate a vehicle with an ACE of either 0.8 or greater or 0.15 or greater. There is nothing about impairment in that statute. So if you have a high tolerance, or if the machine was wrong and overstated your ACE, you cannot defend by saying, well, look, I wasn't impaired. It is a crime in Indiana and most states to simply have a certain level of alcohol on your breath, and therefore imputed to in your blood, and operate a vehicle.
And the person, when a person blows into the machine, that machine is just drawing an analogy, isn't it? I mean, it doesn't really test for alcohol in the breath. It's just looking at infrared beams of light and looking for certain frequencies. That might sound odd, but that's kind of what it's doing.
What the BAC Data Master, which is the machine Indiana uses, does to determine breath alcohol content is capture a breath sample of 50 cc's, and that's about the equivalent of 2 fluid ounces, so the bottom sixth of a soda can. Okay. And that's important later. It then captures that in the sample chamber, and it shoots a laser beam through that sample chamber of a known energy level when it's emitted. It's then captured, and the energy level that remains at 2 different infrared frequencies are measured, on the theory that infrared light is absorbed at those 2 energy levels by alcohol, and the loss of energy that is reported at the end of the beam is all due to the absorption of that infrared energy by alcohol. The truth of the matter is that machine tests energy that is absorbed by the methyl compound within alcohol, and the methyl compound also exists in other common chemicals that you may have in your system, like acetone. If you've had your nails done, a manicure or pedicure, the
Happens to me all the time.
yes,
Or if you've had a diet drink.
correct. They will remove your old nail polish with acetone. So if you work in that industry, you have your fingers in it all the time. If you're a nurse and you commonly use disinfectant of isopropyl alcohol, you'll have the methyl compound in your system through absorption through your skin. If you use a lot of Purell during the day to keep your hands clean, you could have, or if you're a car mechanic and you work in the paint shop, toluene will do the same thing, and many common cleaners or degreasers have it. So if you're a shade tree mechanic, you may have, through just absorption through your skin and working in those substances, the methyl compound not related to alcohol in your system.
It seems to me that they've criminalized behavior that otherwise shouldn't be criminalized. And Joe, I know that you're a very staunch advocate of individuals' rights. In terms of taking a little bit of a different tack on this, on public intoxication laws, and similar laws, for example, marijuana laws, which we're not here to talk about today, we did a few weeks ago, we did drug laws. Generally, in terms of kind of infringing upon an individual's rights and their lifestyle, what philosophies do you bring to this and view this with?
Well, I think that, in my heart, I'm an anarchist and would love to see no laws of, governing any sort of behavior like this. But, I understand that as a practical human being, we have to have laws that govern general behavior. And laws in regards to intoxication, I think, really start to toe that line of where I can tolerate a law over, certain behavior. I mean, we have laws against murder because we don't like that kind of behavior.
Yeah, and we don't have homicide while intoxicated.
Right. Yeah, and why don't we? If we have all of these other intoxication laws, why haven't they taken that next step? But this is the slippery slope that we find ourselves on. I mean, are you going to start criminalizing everything that you do when you're drunk? I mean,
Well, there's one thing that I saw the other day in the proposed contract that the state is considering with CCA to privatize the prisons here, that the state would guarantee a 90% population of the institutions, and that's kind of like saying, okay, we're going to pass laws so we can put people into prison, when I think the whole idea is ideally nobody would be in prison.
and that's why they're using these sort of laws. This sort of intoxication standard is going to just help fill the prisons that CCA needs to run, apparently. And it's this sort of criminalizing behavior issue that is a real problem. I mean, how come we don't have any prescription drug intoxication statutes?
Oh, we do.
Oh,
Yeah.
well, see, this is why you guys are the lawyers.
And, and just to pitch in on that, and I don't mean to interrupt, but to add to your comment.
Could you add right after, because we're at the end of the segment?
Done.
We'll be right back.